Good morning, class. Can you hear me? Confirm if I'm audible.
Yes, sir, we can hear you.
Yes, sir.
Yes, sir.
Yes, sir.
Good morning, sir.
Good morning. So, I have 296 shown on my screen, and I could see some people are already in the YouTube. So, like I said, our test will go today, and before I do that, before we do the test, I just want to also send a note of warning that your camera must be on when we start the test, and also ensure that you have a strong bandwidth to avoid the internet disconnection. So would do a preview of our lecture for 30 minutes and then spend the rest of an hour or so for our test. And so the modality for the test will be made known to you soon as we go on. So, but I just want to appeal to you that irrespective of what you are thinking about, do not allow the tension of the test to affect our lecture this morning. So there's no need to be under any pressure at all. Okay, so the question is as simple as ABC, as we're going to see very soon. So just relax and let's have our lecture before we set the ball rolling for the test. So having said that, now last lecture we brought to bear the facts of occupiers' liability, the issue of how duties can be established under the Occupiers' Liability Act of 1957, and I also look at in what way or manners can these duties be breached, and also we look at the some fundamental decisions between the duty of care under the Occupiers' Liability Act of 1957 and also briefly under the Occupiers Act of 1984 on UK. And don't forget also the fact that we mentioned earlier that Occupiers' Liability Act of 1957, the English Occupiers' Liability Act of 1957, our own tort reform law of 1961 was modeled after it. And so there is no really fundamental distinction between our law and that of UK law. So, and we have talked about the principles generally on occupiers' liability and using the case laws as well to drive home our points. And so on that note, I want to believe that we are well grounded now with the principles of occupiers' liability. Now, I also gave an assignment on the exclusion clauses, disclaimer, and also warning. And I want to believe that the class has done that assignment. So because part of what we want to discuss this morning to look at the likely defenses in occupiers' liability claim. So when that is done, the class can now on their own look for remedies from the avalanche of remedies that we have discussed under the general duty of the general law of negligence and other remedies in tort generally. So now to kick the ball rolling, I want to confirm that are you done with my assignment on those a trial of warning, exclusion clause.
Yes, sir.
Also,
Yes, sir. I don't get time yet.
what do you say?
Yes, sir.
Okay, you're done. All right.
Not yet. Not yet.
All right. So I think I will take it that they are done. So if someone say not yet, I don't know what the best has been doing for the past 2 weeks. So
Weeks?
So I would advise that you forward that assignment to I Adedokun. Let me type it on the chat box. So I Adedokun at I Adedokun 350 at gmail.com I Adedokun 350 at gmail.com. So forward your assignments to that email address. Latest 9 p.m. today. Latest 9 p.m. today. So any assignments that drop after 9 p.m. today will not be reckoned with. Okay, so now can someone from what you have done, from your findings in their assignment, can someone distinguish between the warning, the exclusion clause, and also the disclaimer from what you have put up, from the findings that you have made in your assignments? Okay, we have Chooks. So Chooks number 1, Chooks Nwoko number 1. Are you still in class? Class rep. Class rep, are you in class? Or you're on YouTube? Is class rep in class or on YouTube? And let me pick some jottings. Okay. So I have Chooks. I also have Michael again. Who again? I don't want to call names, please. Just volunteer. Then Olatunji. The okay, Aliyah Rahman. So we'll do this for just 30 minutes. Then we'll move on. Then I also have okay, Goodness Udo. I think Goodness also contributed to my lecture on Monday.
Sir, it's good success.
Okay, so good success. Yeah, good success. Okay, I can see people in YouTube as well. Okay, I've seen them. Then we have Valentine again. Valentine. Okay, so for those that I'm going to call their names as volunteers, I also advise that you drop your names and material numbers. Please just type your names and material number in the chat room as well, so that when I'm listening to the video, I can pick you and I can pick your numbers and score you accordingly. Okay, so now before we go into that, before we go into the assignment proper, I want to chip in one particular point that I was explaining yesterday before, that I was explaining on Monday before the time logged us out. So, and that has to do with Can you see my screen?
Yes, sir. No, sir.
Someone say yes, yes, sir. If I was impressed. When you say yes, sir.
No.
Okay, I'm coming. Let me. So, what can you see? How many things can you see on my screen? How many things can you see on my screen?
Just one
Only
slide.
one slide. Okay, great. So I will not be seeing my question for test. That's what I'm asking. So, which can do? Okay, I'll also call you. Now, you look at look at on the point I highlighted at the last class on how to establish a breach of duty on the common duty of care under 1957 Act. Okay. Now, I mentioned the point on the duty owed to children generally, and I said you should look at the case of Phipps and the Rochester Corporation. Now, before we go to that case, before going to that particular case, by virtue of Section 2(3) of the Occupational Liability Act, now the Act does not allow for variation in the standard of care when it comes to the child. So the duty of care owed to children generally are much more higher than the duty of care owed to adults. And I've also given you the cases on adults. So now, as far as children are concerned, the occupier must take into account that they are likely to be less careful than adults. And so, consequently, what might enable an adult to be reasonably safe may be insufficient in relation to a child. And so, if you look at the case of Maloney and Lambeth London Borough Council, this is where illustrated. That point is well illustrated. The case of Maloney and the Lambeth London Borough Council. So, Lambeth is spelled Lambeth, Nondo, London, Borough Council, Borough, the council aspects. Now, where a child of under 5 years of age tripped or slipped on a staircase occupied by the defendants in a block of flats. So, in that particular case, it appears that the boy fell through a gap in what we call balustrade in England at the time. So, which would not have allowed an adult to pass through in that way. So, the gap was not as wide as would have enabled an adult to pass through the place. So, only a child could pass through that particular balustrade. Now, the High Court's judge stated that in that case that there's no doubt on the evidence before it that the defendant local authority will not know, and if indeed will expect that children of 4 years old will use this staircase unaccompanied by adults. So the bottom line is that if this child had been sent down to the flat below on a message, no one would have suggested that it was too small to take something down or go down on his own to meet people there or to meet his friends. Now, so he did on occasions go down and come up unaccompanied, but the evidence also is that he was a rather timid child and tended to cling to his mother every time he was he moved with his mother. So his mother said that she had told him to use the handrail as he went down, and at his age, will be using the center bar for that purpose. Now, the age here could also be illustrated or could also be explained through the size of the boy. Of course, when you see a boy of a 5-year-old, his size will not be the same as a boy of a 10-year-old. So, to that extent, the court was of opinion that with the photograph that was presented before the court felt that this is a child that the occupier ought to have taken a proper measure to protect. And that was why the court held them to be liable. Now, you look at the fragile nature of a child, which will make the occupier to be much more careful than if it is an adult, the case of an adult. Okay, so in this case also, evidence was adduced to show that in other places, the designs are such that these gaps exist. And in this particular one, using the common sense of the judge in that case, the court felt that looking at the plan and the photograph, it considered the staircase not to comply with the occupier's ordinary duty of care owed to a child of the age of that boy, of the claimant. So the implication of all that I've said is that in the case of child, a duty of care is much more higher, expectedly from that of the occupier than it would have been if in the case of an adult. Now, you can also look at the case of Glasgow Corporation and Taylor. Glasgow aspects, or as pronounced, then a corporation is also pronounced, and Taylor. Now, this is also a case of a 7-year-old boy that died after eating some poisonous berries growing in some public gardens under the control of the corporation. Now, one would know, or one would expect that berries are alluring, ordinarily are alluring to the child. So the child will want to know what's all about. So in finding for the pursuer, in finding for the person who brought the action of the dead child, Lord Atkins observed that they did nothing to protect the child and contend that they were not bound to do anything. So that was their contention. They said they were not bound to do anything. And so Lord Atkins felt that they did nothing to protect the child. So, and felt that for a child, anyone who plants or who keep on his premises deadly berries, which make the child to pluck it, eat it, and suffer great injury, as was done in the case of this boy, the occupier will be liable for the injury caused to the child. So the berries were eaten, and it was highly poisonous. And the court held that the occupier were liable in that respect. So I commend these two cases, for example, to you. The case of Moloney and Lambert, London Borough Council, and also the case of Glasgow Corporation and Taylor. So for further interrogation on the common duty of care as relates to child or children as a whole, coupled with the case of Phipps, as displayed on my screen, Phipps and the Rochester Corporation. It's also a case of a child of a 5-year-old who fell into a ditch, which had been dug for the purpose of laying a sewer on a new housing estate. Now, so in this particular case as well, some of the houses were already occupied. It was known by the corporation that the children were tending to play in the area where the ditch was. So they ought to have covered that place up, knowing full well that the children may likely come to play or near that particular place. So there were exceptions, which are going to tell me from your assignment that you have done. Just let me give that background to know that the degree of the common duty of care expected from the occupier towards a child is not the same as that expected towards an adult. So please, for those that are listening, just keep the hands up. So I'm going to call you one after the other, so that I also score you accordingly. So anyone that is not ready to talk, there's no problem about that. So then, on the warnings, I don't want to preempt what the class want to say on the warning notice, but just to mention that under the Act as well, warning notices, so the Act covers the issue of warning notices and whether they are sufficient to satisfy the standards set by the common duty of care. So, but it must be emphasized that the effect of the warning notice must be differentiated from the effect of a notice which purport to restrict or exclude the liability. That discussion will come to front burner from the class as we go on. Now, what we need to know about warning is that a warning, if sufficient, is treated as satisfying the standard of care under the Act and does prevent there being a breach of duty once that warning is sufficient. Now, but however, an exclusion clause operates on the assumption that there has been a breach of the common duty of care, but the defendant is putting the risk of any such breach either entirely or at least partially on the claimants. So that will also come to forerunner as we discuss through the assignments. So by and large, all these principles could be found under the provision of Section 2, Sub 3, Sub 4 of the Occupiers Liability Act of 1957. So then, again, on the issue of vulnerability of Nigeria, which I also mentioned earlier, as something of risk. Okay, we also discussed that under the defenses when we are done with your warnings, exclusion, and the disclaimer that I gave you. So now, before I come back to class, also note that the requirement that I mentioned in respect of independent contractors, that even the occupier will be liable for the injury caused by an independent contractor because he contracted him to carry out some work for him. And we have discussed this extensively as to the limitations, the limit of his liability as well, of the occupier's liability as well. So, but please note that there are 3 requirements in the provision of the law that will make the occupier to be liable for the act of independent contractor, or that will make him not to be liable for the liability of independent contractor. And so these I've already mentioned earlier, but just reiterate the fact that the occupier must use reasonable care in entrusting the work to an independent contractor. One, so that is, he must ensure that he contracted using his own reasonable care to employ an independent contractor. Then 2, he must take reasonable steps to ensure that the contractor is reasonably competent. So that's number 2. He must ensure that he takes reasonable steps to ensure that the contractor is reasonably competent. And lastly, he must exercise reasonable care in order to satisfy himself that the work is properly done. So it is not enough for the independent contractor to carry out a work but the occupier must also ensure that that work, he examined the work and he found that the work was properly done. So these three requirements can help reduce or absorb the occupier from liability when a claim of such is brought against the defendants. Now, I've already given you the case of Asedin and Door. So as well, and I think I also give you the case of Fleming. So read those cases and make sense out of those cases to gauge your understanding. And then I'm trying to see some cases that, okay, I also give you the case of Ferguson and Welsh. So by the grace of God, before the weekend runs out, if I have the time, I will still put all these cases in the slide for you so that when you are reading, it will assist you not to read beyond the limitation. So that's all I have to say for now. Before I go on discussion on defenses. Like I said, our lecture today is going to be very brief. Before I take this discussion on defenses to occupiers liability, which most of you already know as well. You also need to emphasize the principles as we discussed under liability to trespassers as well. Master the duty of common, the principle of common humanity, which came after 1972. Okay, and look at the cases that I've given you earlier, the case of Addy and Dunbrink. Look at the case of British Railway Board versus Edison. Now, and the young case of Ugochukwu and the Unipetro that I mentioned earlier as well. So then the tort law reforms law of 2013 reflect on that particular law and see whether there's any fundamental difference between that law and the Compatibility Act of 1957. So then yes, another point that I want to make, don't let me go there because many answers are already up. Maybe you help us to reach that stage as well, that angle as well. Now, let me call on the names. The names I have here. The names I have here. Chooks should bear the cat. Chooks, you have 2 minutes. You have 3 minutes to make your presentation. You want us to hear you.
Good morning, sir.
Hello.
Good morning, sir.
Yeah. Good morning. Class. Before Chooks continue, I'll be able to streamline my discussion this morning. Class, did you get the point I made or I highlighted so far?
Yes,
Yes,
sir.
sir.
Okay.
Yes, sir.
Yes, sir.
Okay, thanks. So, do we start now? Someone is, okay, who is talking now?
Yes, sir. Please, I didn't get the last point you made mention of when an occupier can be held liable for the independent contractors.
Okay. You said you did get the point. Okay, I give you you are talking about the three requirements. The three requirements.
Yes, the three requirements. I
Okay.
only got
The last one is that the occupier must exercise reasonable care in order to satisfy himself that the work is properly done. The work is properly done. If you read the case of Asedin and Door, yes, you will see the rationale for that principle, for that point. So it is not enough for someone to deliver a work to you. You need to also examine that work was properly done. So that means you will also take a second opinion of engineers to ensure that work is properly done. So once you are able to do this, then whatever happens, whether whatever the injury of the work delivered by the independent contractor might have caused, you'll be absolved from liability. It is the independent contractor that will be liable and not you. I think that point is noted.
Yes, sir. Thank you.
Oh, okay, all right. So, see, I have many answers, and I'm happy. Despite the fact that some of you are still tensed with the upcoming test. So, I've seen many answers. This is like 10, and that is good enough. Chooks, you have the floor. Chooks.
Good morning, sir.
Yeah, good morning. Can I see you so that I know that you're not talking by proxy. So in 2 minutes, yes. Go ahead. Chooks, I don't let your
Good morning, sir.
don't let your
So,
network
in
fail
explaining
you.
disclaimers notice, exclusion notice, and warning notice, the thing about the 3 terms is that they can be used interchangeably, but their basic use is to limit liability by informing individuals of risks that are involved in involving themselves in certain things. So, for disclaimers notice, a short summary is that it's a legal statement which protects the party from claims related to errors or inaccuracies in provided information. For example, when you go on a website and they give you certain advice to do certain things, they put a disclaimers notice where they say the information on this website is provided as is, and no guarantee is made towards its accuracy. That's a form of disclaimers notice. In its enforceability, a disclaimers notice may not always be legally binding. And then moving on to exclusion notice, this usually states that someone is not allowed access to.
Chooks, sorry, can you relate to your discussion now on disclaimer? Can you relate it with a pure economic loss? If you can you?
Pure economic loss.
Yes, yes.
I might not be able to do it properly, but let me just try. Say you buy something and then it might not be working like properly. You've already lost your money in that regard. That's a pure economic loss. But the people who sold it to you might tell you that they are not liable for any faults with the item.
Okay, go ahead with other points.
So an exclusion notice usually states that someone is not allowed access to a certain area or allowed participation in certain activities. It is done in an attempt to prevent certain legal claims, stating that particular responsibilities will not be accepted by that organization or by that person. For example, when a management states that they are not responsible for any lost or stolen items. So when you go to certain premises, maybe like a bank or a shopping mall, they normally put like on the walls that cars are at owner's risk, meaning that you cannot hold the parking lot, you cannot hold the company, you cannot hold the bank liable in case anybody comes and steals your car, or in case anybody like breaks your window. Any loss you incur when you're in that place, the company or the bank or whatever will not be liable for it. A warning notice, this is easily found around. So it's a type of notice that highlights that there's potential risk or hazard and urges those who might come across it to be careful. So I remember when I used to go to ShopRite sometimes, when the people cleaning are mopping a certain mess, they normally put these yellow signs there to show that the floor is wet and that you should be careful in that area. You should not run or even walk there because you might slip and fall. And so it reduces their liability. So all these notices, the main idea in understanding them is that they play significant roles in managing risk and liability, and they help in mitigating the risk that the defendants might, they help mitigate the risk that the defendants might incur in certain situations. Their effectiveness depends on legal compliance, their way of communication. They must make sure that in communicating these disclaims or these exclusions or these warnings, they are very clear in communicating them, and their effectiveness also lies in how reasonable these notices are. Yes, thank you.
Okay, thanks. So this is 10:05. This is 10:05. So that we can have our test. Let me copy the names of individual that's being displayed on the screen. Then I will take one more comment for now, and I will dedicate Monday next week for your presentations on exclusion clause, disclaimer, and also warning. Then on that day, if time permits, I will run class through tips on how to answer law questions, which Professor Adekele had already done. But just to also add my little input on what can make you do very well in the exam. So, by God grade, that'll be for next week. That'll be for next Monday. So, but today, I want us to end the discussion on occupant liability by looking at few defenses. But I will not touch on the warnings, exclusion clause, based on what we set out to do on Monday to avoid repetition. So just give me 1 minute as I copy the names on the screen. Olatunji, okay, Aliyah, good success, Grace, Onachi, Uba, Ojedokun, Elizabeth. So Omonle as well. Omonle, then Ebenezer. So as many as I will allow to talk next week Monday, I will take as many as I can. So, but for today, let me just leave it at that. I've done the screenshots of those that appear on my screen for today. Okay. Second page. And Victor Chidera. So I think that will be all for now. Let me call on Michael before I go to the defenses for 10 minutes. They will take our test. Michael, you have the floor. Good morning.
Sir, in my attempt to actually differentiate between the terms, I noticed that they are fluid, like they all actually do the same thing.
We can't see you. We can't see you.
Sorry, Mike.
We can't see you. Michael, where are you always? Your background's always I see someone is attending a disco party. That's your background always you as you once attending a disco party. Michael, mute yourself now. Unmute yourself. You are muted. Unmute yourself.
Hello, sir. Can you hear me?
Yeah, I can hear you clearly now.
I said I'm always
indoors,
and the light in the room is this dim blue light.
Oh, great. So go ahead.
Okay. So as I was saying, I said in my attempt to differentiate between the three terms, I noticed that the three of them are almost the same thing. That means they're conflated. Conflated in the aspect that they can be used interchangeably. However, the differences between them can be established in their objectives. The objectives being, okay, I'll start with disclaimer notice. The essence of disclaimer notice is to observe no, it's not just to observe, it first specifies and yeah, it specifies certain risks that if the visitor should take actions, and it results in a loss or damage, the occupier would be absolved from liability. And for exclusion notice, the work of exclusion notice is to exclude certain people from entry into a premise. And also aside from that, exclusion list actually has two facets. It excludes people from entering into a premise. And also it excludes people from doing certain things if they are allowed to enter the premise. Then there is warning notice. What warning notice does actually is to create an information or create awareness as to particular risks that are actually in a premise. The differences between them, I put them in the word that disclaimer notice. Okay, let me read out what I wrote. Unlike disclaimer notice where a visitor can enter at his own risk, or the warning notice where the person can enter bearing the risk in mind, the exclusion notice does either of two things. One, it prevents certain persons from entering into the occupier's premises. And two, it excludes the occupier from being liable for specific or specified harms or injury. And the examples I can think of for disclaimer notice, one of the examples is you can see something like enter at your own risk. We accept no responsibility for damages suffered. So here, the occupier has made it very clear that if you should trespass upon the property, or if, especially for trespassers, if you should trespass upon the property, that whatsoever damages that occur from that is in no way liable. Then for warning notice, one example that you can see is caution, stairs raised are unsteady, do not rest on them. Then for exclusion notice, we can see something like pets and pet owners are not allowed in building, or beware of dogs, not trespassing, owners not responsible for injury caused by dogs. So the thing about these three notices is that they are not fixed and their effects are not absolute. Their effects are subjected to the machineries of the court. And the machineries of the court is actually a matter of fact. Thank you, sir.
Oh, okay. Well, thanks, Michael. Now, I just want to also add this, and I think that will also guide you when you are reading after today on the exclusion notices, warnings, and disclaimer as such. Now, he mentioned something about the effects. So, look at the effect in law, the effect of each concept, the effect of each concept. Disclaimer, what is the effect of disclaimer on liability of the occupier? Does it absorb him totally from liability? Does it limit his liability? Okay, so they look at the effect of that in law, of the disclaimer in law as well. Look at also the effect of warnings in law as well. Now, this will help you to understand the way the law look at these three concepts. That's very key. Then I also advise that you can look at the differences between these three concepts under the Occupational Liability Act of 1957, under the Occupational Liability Act of 1984, and under our tort law reform, our tort law reform of Lagos 2013. So look at that. I won't say more than that for now. Now, before we go on to take our test, just 10 minutes, let's look at the defenses to occupiers liability. Defenses to occupiers liability. And like I said earlier, these defenses are also known to you. Examine the defense of contribution negligence as well when you are looking at what kind of defenses are available to occupier where he is faced with occupier's liability claim. So contribution negligence, look at that. And generally, we say there are two general defenses of contribution negligence and voluntary non-fiduciary. These are the two defenses majorly that are available for actions concerning breach under the 1957 Act. Then, in addition, occupiers liability, occupiers can also protect themselves from liability by the use of warnings, exclusion notices, disclaimer, subject to the rules under the various laws. So I've given you five in one now. I said we have two general defenses, which you already know: contribution negligence and voluntary non-fiduciary. Then you now have the additional one, which occupier can protect himself with from liability by the use of warnings and exclusion notices with disclaimer as well, subject to the rules as we'll converse later. Now, for contribution negligence, if you look at a provision of section 223 of 1957 Act, it specifies that in considering whether an occupier has breached the common duty of care, the court may take into consideration or an account the degree of care a reasonable visitor can be expected to show for their own safety. For their own safety. So you don't just go to a man's house and say because he has invited you to come to his house, then you go to his kitchen and you light up his gas, and something unthinkable happen to you, and you say, because you are in his premises, then what happened to you there, you should be liable. So the case of contribution negligence can avail the occupier in that situation. So, and like Michael said, and like I've always emphasized in this class, the fact of the case will determine whether an occupier will be liable or not. So, if the occupier has taken reasonable care or reasonable precautions, he has done everything imaginable to ensure the safety of lawful visitors, even to ensure the safety of trespassers, as we have discussed, then you cannot say that we should kill the man because of the negligence of the visitors on his premise as well. So you have to look at this. Then, aside from that, you can also look at the principle of voluntary non-faith injuria. Okay, of course, you know what we say voluntary non-faith injuria. You know that literally it means no injury is done to one who consents. That is just the meaning literally. So no injury is done to one who consents. So if that is what that principle stand for, then the occupier can raise that defense where an occupant's liability claim is brought against him. So, versus law of injuria, there are instances of versus law of injuria, and I'm sure that if I was to mention it, then you give me numerous. The list is inexhaustive. So look at that as well. Then you look at warnings, you look at exclusion clause, and also disclaimer. So let me see if I can bring out a particular scenario from that law. Okay. So that is that's on defenses under the 1957 Act. Then if you look at the liability as well to visitors, to lawful visitors under the 1984 Act, then we also talk about the contributory negligence as well. And same principle also apply. Okay. However, the 1954 Act is used to determine the scope of the duty owed, and so the findings on defenses are likely to be relevant to cases of true occupiers liability. So now, in the case of Revu and the Newberry, of course, Revu is spelled REVILL, and Newberry is spelled NEWBERY, Newberry. Okay, so equality negligence has been to be a defense to actions against trespassers. Okay, so in that case, the claimant's damages were reduced by 2/3 because of the claimant's contribution negligence in coming onto someone's land in the middle of the night and acting in a manner that was likely to make the occupier suspect wrongdoing. So if someone comes to your property in the middle of night, okay, so of course you may see the person as an armed robber, and if anything happens to the man on your premises, maybe through the barbed wire, and so the man sustain injury, at best, contributory negligence can be used to reduce the liability of occupier. And you see, remember your principle of apportionment under negligence. Okay, so it's still the same principle here. Now, then for voluntary non-fit injuria, Section 1 sub 6 of the 1984 Act, for example, provides that no duty is owed by virtue of this section to any person in respect of risk willingly accepted as is by that person. So if you willingly accept a risk, then no injury will be done to you. Look at the case of Tishner versus British Railways Board. Tishner is spelled TITCHENER, and British Railway Board. It was stated that adult claimants are regarded as accepting any risk which they knew about when entering the land. So now, should this principle apply to the 1984 Act, then the defense of voluntary provides greater protection for occupiers with regard to trespassers than it does with regard to visitors, where the defense only apply if the visitors knows enough to be reasonably safe. So look at this case as well. Then I look at warnings and also exclusion clause. Then damage as well. Damage under the 1984 Act is that one major difference between the 1957 and 1984 Act is that the latter only allows claims for death or personal injury. Unlike visitors, trespassers cannot claim for damage to property. Now, part of what I was expecting your presentation to tell me is to also look at the what we call Unfair Contract Terms Act. I'm sure you are aware of that law, Unfair Contract Terms Act of 1977, which exclude liability for death or personal injury. So it prevents an occupier from excluding liability for death or personal injury. So if you like, put a disclaimer, put a exclusion clause, put warning. You cannot contract out death and personal injury caused by negligence of the occupier. So where an occupier is acting in the course of business or from premises used for business purposes, liability for damage to property can only be excluded if it is reasonable to do so as well. So we look at this when you are presenting your paper, your assignment next week, Monday. So those are the things that I felt let me bring to your attention before we go on. Now we have an hour left. Yes, we have roughly an hour left. So our class is supposed to end by 11. Okay. 30 minutes. You have 30 minutes. So I think 30 minutes should be enough to write the text. Now, I would say if you are set for the class, can you turn on your camera now? Can you all turn on camera? I'm going to turn on my camera as well. So, and like I told you, the answer should not take you more than 30 minutes to write. So for those that have where's my camera? Okay, for those that have what do you call fast fingers? How many of you have fast fingers? Many of you. I could see Chuk is happy that test is about to be read out, and also Ojuku Chinoye. So I could see the smiles. So we are indeed ready. So is Afolabi Grace, are you here or you are on YouTube? Afolabi, are you here on YouTube? Afolabi Grace and Ojedo Kumbulu, are they here on YouTube? Bolu Ojedo Kumbulu. Bolu Ojedo Kun, are you here?
Yes, sir.
Okay, so then why do you suddenly lose your voice?
Not this.
Okay, so Bolu and the okay, Grace is I can see Grace Unachi. So Grace, Bolu and the Grace Alabi, is it Alabi? Am I right? Your friend that was with you yesterday night, when I saw the two of you, Bolu, is it Grace Afolabi? Hello, Bolu. Bolu, are you here?
Yes, Grace.
Bolu, what's the name of your friend that was when you were engaging me yesterday on some topics?
I didn't expect to play because when I sent from Manchester, I thought that I will be back. But we played for 1 more year. And so
that is AI. That is AI at work. Ogunbamila, Temiloluwa, you are disturbing the class. Ogunbamila, Temiloluwa, you are disturbing the class.
No.
Why not? So you are having another class when you are in class, or you want to use AI to answer your question. So you've already contracted an AI to be by your side. So because that voice is not the voice of normal human being, the person that was talking there. So, but Bolu, what's the name of that? What's the name of that person, Bolu?
Grace Obafemi.
Grace Obafemi. Obafemi. So Grace Obafemi, are you here? Where are you? Grace Obafemi, where are you? You. Grace Obafemi. Or you are in the You are on YouTube. Okay, so in not more than 30 minutes, I'm going to display the question now. And please note that this session is being recorded. So if by chance, after reviewing the entire camera, I discovered that that you sought for assistance somewhere, then you may not have any score at all. Please ensure that you do not allow anyone to distract you when you are writing. So let me share my screen for the text.
So your network is breaking.
Oh, who said my network is breaking? It's not breaking now. I'm not seeing anything. I didn't see anything now. Can you see the tension now? I've not even said anything. You said my network is breaking. Okay, so have you seen the screen? Have you seen the screen? So you sent to my email.
No, sir.
Okay.
So we can't see your screen.
There is nothing showing on the screen.
Okay, you see it now. So you sent to my email when you are done, and I'll give 10 minutes to send it to my email. So your test is so have you seen it? Have you seen it?
No.
Who said no? Have you seen it?
You can see.
You see it? So my test. Hello, class. Can you see it? So it is not. This is my test. Like I told them yesterday night that I'm going to ensure that we do a test that all of you will be happy. So it's an assignment, not a test. I've disappointed you now. It's an assignment, not a test.
Thank you, sir.
Can you see why it is good to be prayerful?
Thank you, sir.
Thank you, sir. I had the blood.
Thank you so much.
God bless you.
Oh my God.
Yes, so you are the best, sir.
So as I see the screen, please let's run through it together. And
That please, question 2 is not showing very well.
yeah, you see it now. So
please, no more surprise.
Continuous assessment, answer all questions. Someone said no more surprise. Who is the person who said no more surprise? Then we draw it and give you live test.
No, sir. No.
I don't mind that, please. She doesn't
I
speak
don't mind that.
to all of us.
It's sure that making her talk like that.
That's why.
Yes, sir.
Thank you, sir. But the third question is not showing. It's not showing on the screen, sir.
The person is sick. Don't mind the person. The person is sick. The person is sick.
I will send your class rep. Hello, I will send your class rep now. So that you can. So look at it. Can you see the one on the screen? It says answer all questions. Answer all questions. Please note this. Answer should not be less than two pages and more than 2.5 pages. Where typed excluding the title page. You see that one? Then on the second question as well. The answer should not be less than 2 pages and not more than 3 pages. Where typed excluding title page. You see that one as well? Hello, class. Have you seen that one as well?
Yes,
Yes, sir.
So the written format is this.
Sir, can you please give me?
send this thing to
Two questions different.
Don't worry, I will share with your class rep to send on your platform.
Okay.
Now, read the following written format, written work format. Answer each question in a separate paper and indicate each question on the paper accordingly. So don't lump all your questions together, or don't lump the two questions together. Answer them separately, as if you are writing exam. Answer them separately, and you have to submit a hard copy of your work at the Department of Private and Property Law office. The pages must comprise of font size 12, time Romans, spacing 1.5. Please, when you are seeing this red flag, be careful. If you don't follow the instruction on the red flag, you are doing yourself the service. The submitted papers will be subject to AI, and if you plagiarize, you'll be penalized. Any paper that falls short of the required standard will be severely penalized. Don't use AI and do not plagiarize. It's clear. That's why I put it on the red flag. Now, students should ensure that the mathematical number has been accurately typed before submission.
So when are you submitting?
To submit the soft copy of your paper, send the two assignments, not PDF, please, not PDF, as one file to ISSA ADEDOKUN350@gmail.com. Organization, follow a logical structure, e.g. introduction, main points, conclusion. Deadline.
Sir, please, I have a question.
Please, let me just read it out for you. Now, you have 40 hours to submit. 40 hours is between now and Friday. Is between now and Friday. That's 40 hours. But
hello? We can hear you, sir.
Okay.
We can hear you, sir.
You have 40 hours to submit, but because of weekend, so I'm giving you additional weekends. So instead of you submitting on Friday, submit on Monday. That's 10th February 2025 before 2 p.m. Hard copy submission. Soft copy must be submitted by Sunday 3 p.m. not later than 3 p.m. on Sunday. Paper submitted after deadline will not be counted. Please note this. Paper submitted after deadline will not be counted. So for those that will be scoring 1 mark, 2 marks for presentations, during the presentations that we're going to do next week Monday, your mark will be included in your this score. So you know what that simply means that if you score 10 or 15 in one CA and you have scored 1, 2 marks in your presentation, that will be added for you. Okay, so for those that volunteered last week in my class, they already scored 1 mark. So you think 1 mark is a small mark. But when it's called 69, you know the meaning of 1 mark. So I have their names here already. So those who have already scored 1 mark. So if they score 10 here, that means they have 11 marks. So I'm going to send this instruction to your class rep now, so that you can send on your platform. Okay. So any question, any clarification before we go?
Sir, I have a question.
Go ahead, ma'am.
Are we to submit it to the soft copy of the assignment and the hard copy of the assignment, or we should just choose?
I just read to you now. You are submitting both. I just read to you. Ordinarily, I would not have interpreted this question for you. You go and interpret it yourself. But I just read for emphasis sake. That's why I've done what I'm doing here. So hard copy submission on the 10th. Online will be submitted on the 9th.
No, sir.
So what do you mean by separate papers?
Okay. Ask your classmate, they will tell you that.
Yes.
So,
sir, sorry, excuse me, sir.
On that note, I'm done with that particular task.
I have a question, sir.
I have a question, sir.
Go ahead, sir.
Sir, you mentioned those.
I said you said that we should. Hello?
I can't hear you.
Hello, sir.
Go ahead.
Hello, sir. So I said that you mentioned that we should not.
I can't hear you.
The assignment should be in one file, not PDF or something of that sort.
Did you read to you? Did we read to you your assignment on legal writing? Did we? So why are you taking unnecessary benefits or advantage? Read that. When you see your question, you be pledged.
Hello, sir.
Do you have any question?
I have a question, sir. I have a question, sir.
Do you have any question?
I have a question, sir. Can you hear me, sir? Hello, sir.
Please, can you leave the floor for another person?
Sir, I have a question.
Please go ahead.
Sir, you mentioned those who are supposed to make presentation, the names you took down.
Yes.
My name is Among, but I actually spoke today. Do I still need to prepare against our next class?
Is that my case? No, now you're done.
Okay, sir. Thank you, sir.
I have a question.
Hello, sir. I have a question, sir.
You understand? Please, if you don't have any question to ask, can you lower your hand, please? I can see Grace hand. What is the question?
Hello, sir.
Grace, what is the question?
Yes, I have a question.
Go ahead.
Okay, sir. Thank you. So I wanted to ask for the physical submission, can we submit by proxy? For people that stay far and might not be able to make it down to school between now and Monday. Also, I would like to ask for the earlier assignment that you gave to us, the deadline, does it still remain 9 p.m. today?
By the grace of God, if you don't submit by 9 p.m. today, please I do not submit. If you don't submit by 9 p.m. today, do not submit. Okay, if you don't submit by 9 p.m. today, please do not submit again for that assignment I gave. So then the question that you asked about proxy submission, yes, you can submit by proxy, but ensure the person record I've told them in the department to open a file for you. So as you're submitting, you are writing your matric number and you are signing out. So there's a book. Ensure that you write your incident in your name when they collect the paper from you. So they'll give you a book. You write your name there. It's a book of life. So you write your name there and you sign out. Okay.
Thank you, sir.
All right.
Good morning, sir.
Good morning.
So when some of us were at the YouTube before now,
yes,
especially when that contributions were being made,
yes,
and we hadn't the same privilege of, raising our hands up to make contribution,
yes,
and also perhaps to give us the opportunity next Monday to, I don't know, I just managed to come on here.
Okay, okay. Mr. Obi, is it Mr. Obi or Miss Obi? Because I can't see your face. Is it Mr. Obi or Miss Obi?
Yeah, Stanley Obi, yeah.
Okay. Stanley, for those YouTube, of course, if you are indicated, when I look at my video again, I will actually look.
I didn't indicate on YouTube because I don't know how to go about it there.
But you'll have sent a chat now. You'll have sent the chats. Of course, a chat box is always there now. You have a chat box.
Okay.
You can always chat. But don't worry. Just mention that when we come on live next week Monday. So
okay.
On that note, I'm leaving the class. I'm committing your hands to able God. So if time permit, we'll run through the defenses again when you are done with your presentation. Otherwise, you're going to read them on your own. There are surprises. Okay, and please, class rep, remind me, I've been calling her, it's not responding. Who is deputy class rep? Is it Daniela? Daniela, you here?
Good morning, sir.
Okay, good morning, Daniela. So are you the
So I'm
deputy class
not
rep?
the assistant rep.
Who is the assistant class rep?
No, sir. It's Kinoshiayo.
Are you here? I mean, if I
Good
call
morning, sir.
your class rep and it's not responding,
Oh, he's on YouTube.
why would the class rep move to YouTube?
Network problems.
Okay. So, but when I call a class rep and it's not answering, you have to stay up.
Yes, sir.
Yes. Because your liability will be several and joints as well. So, on that note, Ebenezer, are you saying something that we don't know?
Hello, sir.
On that note, we see on Monday. So I'm sending to your deputy class rep. You can also forward your WhatsApp. Let me forward the text or the CA to you or to you as well, so you can force your classmates if the class rep won't be able to do that early enough.
Yes, sir.
All right. So take care. Please do not plagiarize. I want you
just mention that.
So I have a question.
When we come online next week.
So it's Gabriel.
On that note, I'm leaving the class. I'm committing your hands to evil God.
So I don't go yet.
So if time permit,
ask your question.
Run through.
Who's already playing the YouTube? Who's that person?
Sir.
Go and read them on your own. There are surprises.
Sir, can you hear me?
And please, class rep, remind me. I've been calling her. Your meeting is not responding. Who is deputy class rep? Is it Daniela?
Sir,
Daniela,
yes, sir.
Good morning, sir.
Good morning.
So are you
the assistant rep.
Who is the assistant class rep?
No, sir.
I'm the one, sir.
Are you here? I've been calling.
Good morning, sir.
Good morning. Go ahead. Go ahead now.
Oh, hello, sir.
Yes, go ahead.
Sir?
Someone was saying good morning, sir. Shoma, why are you laughing? Do you have any?
Oh, you were asking for the assistant coach rep, so that's why I answered.
Okay. No, it's YouTube. YouTube was a bit slower than the regular class.
That
So
was are you something that we don't know?
Sir.